There we go. All right. Good morning, everyone. Could you hear me? I don't think they can hear me.
They can hear.
Oh, if you could hear me, can you just hold your thumbs up for me? Perfect. Thank you so much. Susan, were there any shelter here?
I didn't see any general.
Okay, that's what we're hearing. So, first of all, to everyone, good morning. I'm Judge Ginger Lerner Wren, and I would remind everyone that this is a first appearance hearing. I'm making some limited findings as to probable cause, giving information, advisements as to bond, etc. And so when you hear your name, please come forward. And I'm starting with Cecilia Nicola Dillon. Good morning. Morning, counsel.
Good morning, Judge.
Now I can hear you. Okay, excellent. Thank you. And good morning, Ms. Dillon. And first of all, this is an arrest for one count of domestic violence battery. I did review the probable cause affidavit. I did find probable cause. And I was going to set bond at 500 with no victim contact. No victim contact. Thank you. Direct or indirect. And I know that's probably that might put her in a challenged position because I believe according that this is intra-family.
Yes, Judge. The alleged victim is one of her children, but she also has 3 other kids. An 8-year-old, a 13-year-old, and a kid in college. So if we can she be allowed to have contact with the other family members?
Sure.
And
This
her
doesn't
kids?
relate to anybody other
Right.
than the alleged victim. Absolutely.
Okay.
All right.
Judge, I know that Your Honor said a $500 bond, but I think that she can afford a $300 bond.
That's fine. No objection.
Thank you so much.
You're welcome.
Okay. Go ahead.
Uh, let's see. Luisa Maria Oliveras. Hello.
Hi, ma'am.
And good morning. And first of all, I'm seeing there's an outstanding violation of probation warrant. You will be seeing your division judge. It looks like April 9th at 9:45, and there is an outstanding capias on a misdemeanor case. All right? Thank you very much.
Yes, ma'am.
And Kathy Akins. Kathy Akins. Here she comes. I see her. Good morning. This is a can you hear me? Thank you. This is a violation. You look fabulous. Of a municipal ordinance, and essentially, I can't tell by the paperwork exactly what the nature of the municipal ordinance is.
Let me inquire, Judge. What was the municipal ordinance for?
If she knows.
Was it for sleeping in public on the street?
Oh, I did go to jail with
Judge, it was for sleeping in a park.
Okay. And was she interested in any assistance in terms of any homeless services?
Actually, she was trying to move into a new place. She found a place, and somehow, because she had a KPS on the municipal ordinance, because she was at large, then in the process of moving in, she got arrested. So I think that she doesn't require those services right now. She's She's obviously made strides to get on her feet. I was wondering if Your Honor would be willing to give her an offer this morning of
Yes,
time served.
Of course I would. I would be happy to offer a withholding of adjudication, no adjudication, no conviction. Is she on a fixed income, do you know?
Are you on a fixed income? No, Judge, she's not on a fixed income.
Okay, well, I certainly would give her time to pay. How much time would she like to pay her court costs of $293? Whatever she needs, I'll give her.
6 months?
How much?
6 months?
How much?
$300 for the cost of
12 months?
Yeah, I think 12 months, Judge.
Sure, she
In
could.
order to be able to pay it.
And just for the record, I would allow her to make partial payments over time, correct?
Thank you so much.
You're welcome. Good luck.
Thank you.
And next I have Ruth Marsul. Marcel. And this is traffic. Do you have any records with you by any chance? Do you want to hand them to me so I don't have to bother you? It's such a long sketch, isn't it?
It was Paul Ryan, Your Honor.
Oh, thank you. There we go. Hello. Good morning, everyone. And are you Ruth Marcel?
Yes.
Thank you so
Your Honor.
much. And Madam, this is for one count of driving while license suspended or revoked. And just for the record, I do find probable cause and state there's one prior in 2004. The suspensions appear to be, for financial reasons. Were you open to me making an offer?
Of course, Judge.
This is Michelle. This is Ruth Marcial. I'm sorry? No kidding. Oh, good for her. Okay, fantastic. Your bond was posted. So you're gonna be released, okay?
I thank you.
You're very welcome. Good luck. Don't drive. I mean, obviously. And Chantel Sinus? Thank you. Bond posted. And next I have Samantha Schneider. Good morning.
How are you?
I'm good. Thanks for asking. And these represent ad charges. 11, don't comment, just listen if you don't mind, although I appreciate the dialogue, but not right now. And so this represents 11, counts 11 and 12, one for grand theft, one for the fraudulent use or possession of ID of another. I did find a probable cause on both counts. Bond on each is set at $1,000. All right, thank you very much.
Okay, what date do I see my division judge?
Let's see if we can get that information for you. We don't have that date quite yet, all right, but it'll be soon. Thank you.
Okay.
And Kachik Campbell,
North Broward.
thank you. Hello.
Hi,
Hi, how you doing?
I'm in pain.
I see that. I see that. Is anybody assisting you from medical services?
No.
Okay.
Same thing like last year when I had my baby here. No. This is the horriblest jail you got. Literally.
Okay. Well, we have jail staff here, don't we? Anybody from crime and status? Could you do me a favor? Would you be so kind as to send an email requesting a medical screen for Miss Campbell to correct? Oh, I would appreciate that. Okay. Okay, well, I'm going to do the order. Can you also, in the meantime, are you able to send an email? Just to speed it up? No? If you can. Oh, you can? Okay, fantastic. All right, excellent. So first of all, you have a couple of no bond hold felony capiases out of Judge.
I never received an email. I never received nothing in the mail.
Okay, well, I'm giving you
That's
that
what I don't
information
understand.
right now about it, and I can't comment any further because I don't have any further information. So I just wanted to let you know that. You've also been arrested on one count of fraudulent use of possession ID of another without consent, one count of possession of methamphetamine, one count of drug paraphernalia. I did find probable cause on all counts, and they carry bonds of $2,100. 1 second, please. And you will see your division judge on April 8th at 8:30 a.m.
The
Yes, ma'am.
IDs, like that's
Please
my,
don't comment on any facts. Please don't,
no,
and I'm
it's
sure
my
counsel.
boyfriend's ID.
Thank you very
my
much.
boyfriend's credit card that I.
Don't talk about
I'm
the facts,
shutting the
ma'am.
record down, just for the record, just to protect her. Thank you. Okay, how do I get this back on? Let's see. All right, we're on. I guess I can check this. Okay, Yvette Secunda Tharp. Thank you very much. Medical reset. Madam, thank you. I have these here for you. I'm just letting you know. No rush. Ashley Horton. Good morning, Miss Horton. And you have been arrested on one count of grand theft, one count of possession of drug paraphernalia, use, possession, manufacture to transport. It's grand theft, yes. And just for the record, I have reviewed the probable cause affidavit, and I did find probable cause. I was wondering if Ms. Horton has been screened for any pretrial release. I couldn't hear you, I'm sorry. Do you have a place to live, madam?
No, ma'am.
She doesn't judge.
I see. Okay, well, thank you very much. There is a bond. It's set at $1,000. Thank you.
Judge, she's not able to afford that bond. Is there any way that the court could consider maybe RORing her if she promises to appear at her court dates? She has a homeless shelter that she usually stays at. What is that?
I'm not sure.
You know, you can't access homeless shelters like that. They have to go through a coordinated entry point. So you can't, I don't know what she's referring to.
Okay. Thank you so much.
She has, okay, I'm hearing that she's got priors out of Tennessee. All right, thank you very much. The bond will stand. Could I trouble you for one more short order? I kind of messed it up a little bit. Could I trouble you for one more short order? I messed it up a little bit. I apologize. I'll draft it. Oh, thanks. Give me 1 second. You know that, right? Thanks. One second. Bear with me. Now, let's see. On Miss Campbell, do you have a case number or you just have? I could write, I don't know what this number, that 57, is that the arrest number? Do you want the arrest number? Okay. Thank you. There you go. Next, I have Christine Emile.
Good morning, Your Honor. Zadika Carr on her behalf as to count one, the municipal city ordinance.
Thank you.
Welcome.
And first of all, I'm not exactly sure what that is per se. There's also, it appears, an outstanding no bond capias out of Judge McCarthy's division. So the municipal ordinance, based on the probable cause affidavit, appears to be a petty theft.
That's correct, Your Honor. She was alleged to have
Right.
taken items from Target, but they were returned, recovered, actually.
Understood, so
Federally.
noted. And I did find probable cause, just for the record. So you will be seeing Judge McCarthy on that, and with regards to the, I would ROR on the petty theft.
Your Honor, when it comes to count two, it was actually a non-in-custody capia, so it's a no bond hold for magistrate. She needs to be magistrated.
Oh, okay, but I don't have, I don't know that I have any information on that case.
Judge, I have a copy of the PC.
Oh, you
for the
do?
underlying
Okay,
offense.
fantastic. Because they don't give me that. Of course.
May I approach with my order, Judge?
Sure. Absolutely. All right, if you could just give me 1 second. And just for the record, I have reviewed the arrest affidavit. This is from, for the record, from May 16th, 2018, and I did find probable cause. And this is, I believe, is a second-degree felony, and I was just gonna, just any recommendations as to bond, and then I'll hear from defense.
Your Honor, given the allegations, I would just be asking for a $7,500 bond because she did throw a brick through a window and almost hit a 1-year-old child that was in the car.
Allegedly. And, Madam, can you review any priors for me?
Yes, Judge. Let me-
One second, please.
Do you have priors?
Your Honor, I just see some misdemeanor priors. From 2013, there was a compulsory school attendance charge. From 2015, operating without a valid driver's license, and then another compulsory school attendance charge from 2018.
And do you have a place to live?
Yes, ma'am.
Are you working?
No, ma'am.
How old are you?
I'm 29.
Okay, Judge, I believe that the only bond that she can afford is $500. She didn't. She has kids, and she's trying to get her life together. I think that she wasn't properly noticed to appear in court, and that's why she missed court. I argue that a reasonable bond for this felony would be $500 that she can actually afford. $7,500 is tantamount to
I
no
hear you.
bond if the
Madam,
person-
I'm drafting. Give me 1 second, please.
Oh, thank you so much, Judge.
I'm drafting.
Sorry.
That's okay. You don't know that. How would you know unless I tell you? No, I hear you. And, you know, she really doesn't have, just for the, oh, she's not, okay, she's not on. Wait till she comes back. Hello? So this is my thought. It's basically twofold, pretty basic, that I would go ahead and allow the $500 bond because you're indicating that she can afford that. But I would like her under just a pretrial release order. Standard is fine, just no contact, direct or indirect, with the alleged victim in this case. No contact. That means over social media, that means any contact, not using a third party, nothing. Nothing. Understood? Is that understood?
Yes, ma'am.
All right. Let's move.
Thank you so much, Judge.
Yes, she's $500 bond as to count one with with a pretrial release supervision. Standard.
Or as to count one.
With regards to the felony count. That's correct.
Good to see you, Judge. Have a great week.
Thank you. Next, I have Nicole Ashley Incline. I'm going to write it on this. Yeah, I just wrote it on that. I don't think she needs it. There you go. All right, good morning.
Morning, Your Honor.
Okay, the defendant has been arrested on one count of aggravated battery with a deadly weapon, one count of aggravated assault with a deadly weapon without intent to kill, one count of criminal mischief as a misdemeanor. And just for the record, I did find probable cause on all counts, and I'm asking, first of all, if I can get some guidance or input with regards to bond.
Your Honor, she does, her only priors are out of Miami. It was a battery on a law enforcement officer, but that charge was dropped. Based off of the allegations, though, in the probable cause, I'd be asking for a $5,000 bond on count one and a $2,000 bond on count two.
Thank you.
I'm not done. I didn't accept that. I'm not done. Give me 1 second, please. Do you have a place to live?
No, I live in my car because I was trucking prior to this.
You were what? What did you say?
Driving trucks.
She's a truck driver, Judge.
I'll set bond at $5,000 as to count one, $2,000 as to count two. In the event she is able, and there is a, just for the record, there's a $100 bond on the criminal mischief. In the event that she is able to bond, understanding everything you just said, including obviously the challenges with regards to the homelessness issue, and I recognize that and I appreciate that. However, given the severity and the aggravating nature of the allegations of the arrest affidavit, I am asking that she be supervised by pretrial release on. I don't see how I can do, for example, an electronic monitoring under the circumstances, but absolutely no contact, direct or indirect, with the alleged victim, no weapons of any kind, and no return to that location. Do you understand?
Yes, Your Honor.
Thank you.
Okay. Yeah, that's it.
I'm sorry, I can't hear you. I'm sorry. Can you repeat? I'm sorry.
Are you putting her on standard pretrial supervision or GPS level 2?
You know, if you can put her, if it turns out that she ultimately finds residential placement, then I would want her on a level 2. Otherwise, I'm not clear how you can feasibly do a level 2. Do you see, right, under that condition?
Respectfully, Judge, I don't know if she's gonna be able to bond out and be on pretrial if she's at large. It's
Okay, but I'm not commenting on that. I'm just saying, in the event that she can, I understand that might be very difficult.
Thank you, Judge.
Thank you. Brianna Ryland. Good morning. And Ms. Ryland, you have been arrested on one count of petty theft, one count of possession of cocaine. And just for the record, I did find probable cause. There is a bond. It's set at $1,000, and I didn't know if perhaps she was screened for pretrial. Okay. Do you have a place to live?
Yes. Yes.
Okay.
She does.
Could I get order her in pending verification and otherwise being qualified? I don't know, I didn't ask about her priors, but. And if she does qualify, if she can't post the bond, are you able to post that bond?
Yeah.
Oh, you are able to post the bond. Okay, then strike that. Thank you very much.
Thank you. Okay, you can go back.
And Alexis Sade Crooks. No.
All
she's-
right, Your Honor.
Thank you. Good morning.
Good morning.
You have a number of outstanding capiases out of Judge Siegel's division, and if I did the math correctly, first of all, there's 5 counts, and they total $16,500 in outstanding bonds. Thank you. That's it. And Sarah Emily Rip.
It was North Broward. I did not speak to her, so I don't know if that's a medical reset, but it was North Broward.
Yeah, it was a medical
previously.
reset. I don't know if this person is available. Anybody, any information on a Ms. Rip?
Sorry.
It's a reset. Thank you. Are you Miss Rip? That's somebody else. Okay. This is Mrs. Lunstead, correct? Thank you very much. And, ma'am, you have been arrested on 1 count of possession of cocaine, 1 count of possession of drug paraphernalia. I did find probable cause. There is a $1,000 bond. Are you able to make that bond?
I'm not sure yet.
To be blunt with Your Honor, she's also being held no bond on a different count.
Oh, I see, that I don't know about. Okay, well, thank you very much. Good luck.
Okay. So
And I
what's that
did-
mean?
You're being, I'm getting information that you're being held no bond on an unrelated count. So I'm giving you information about your $1,000 bond on this count.
So when do I see a judge? Do I see a judge another day?
Another day, correct. You'll see your division judge, correct.
I emailed, just so you know, Ms. London said I'm going to email your public defender so they know to set you, okay?
Okay. They'll let me know right here, right?
They'll let you know.
Absolutely.
Okay.
Thank you. And I think it's Emma Elisa Orsino.
All right, Your Honor.
Thank you so much. Good morning.
Good morning.
And it looks to me, Mr. Orsino, that you have an outstanding violation of probation matter, and you will be seeing your division judge on the 9th at 9 a.m., just a few days. Thank you. Good luck. And Balat Dolko. Hello.
All right, Your Honor.
Thank you. Hello.
Good morning, Your Honor.
Good morning.
They got me on that name. That's not my name. My name is Clemeline Jean. I think it's a mistake, Judge.
Uh-huh. Okay. What I have here is a outstanding violation of probation matter before Judge Coleman, and you will be seeing your division judge on the 9th at 8:30, so you can discuss that with your division judge, all righty?
Your
You're
Honor,
welcome.
I do know that it's a violation of probation. This is, Ms. Dolko, don't move yet. The warrant is from 1988, so the warrant's from 31 years ago. I'm asking Your Honor if you would consider putting her on pretrial and then she sees the judge and then they take it from there. But this has been outstanding for 31 years.
I would simply say that I understand that. One second, let me grab that back. Stay.
Yes, Judge. I'm actually in this division, and this case would be mine, so I'd be more than happy to deal with this in front of my judge on the 9th.
Right, but let's see. Give me 1 second. It's a little complicated, if you don't mind me saying, because of an issue that I don't want to talk about on the record. So if you don't mind, I'm going to let it go to the division judge, okay? Thank you. I appreciate that, and I really do appreciate that, thank you. But that might have been an issue with the timelines and, it'll be responded to. Rodrigo Vega.
Housing facility, Your Honor.
Thank you. Good morning, sir.
Good morning, Your Honor.
Thank you. And this is, it looks like an ad count. It looks like number 4, and it's for 1 count of violation of a protection order, domestic violence, and I did find probable cause on that particular count. And I would simply ask, I don't know exactly what's holding him and currently, but any recommendation on a bond for this, is 1,000 sufficient?
Yes, Your Honor, that's what I was going to be saying.
Oh, okay. All right, thank you. $1,000 bond. On that will be count 4. Thank you, sir.
Thank you so much, ma'am.
And Ricky Lamont Jackson.
No problem, John.
Thank you. Hi, Mr. Jackson.
Yes, ma'am. This situation is.
I want to speak about the facts, sir.
Mr. Jackson, hi. I'm
you
just
doing?
good. I'm gonna ask if you would do me a favor and you a favor, and just don't talk about any facts, because anything that anybody says,
Right,
can be used against you. So is that okay?
No, I would like to go pro se. I want to speak
Okay.
myself, the situation.
All
what's
right,
going
but you
on.
know something, I hear you, but there really isn't anything that I'm able to do today other than
Right.
simply ask. I have to ask a question. Could I ask a question?
Yes, sure, ma'am.
But not of you. Not of you. Not of you. This is a little unusual for the paperwork in the sense that it's indicating, I guess, ad charges 2 through 5. Looks like it's coming out of a family law division, a family division, and they're for contempt counts. And my paperwork, essentially, give me 1 second. Give me 1 second. So, I guess the question that I have is this, for example, this is not coming from the judge, this is coming from this is the purported charge. Is that what I'm understanding?
That's correct, Your Honor, and count 1 is actually the same charges as well.
Okay, so just for the record, I do find probable cause, and he is detained, obviously, and I would just simply ask on those counts, what is your recommendation at this time?
Your Honor, Judge McHugh actually signed a $1,000 bond on count 1, so I would just be asking for a $1,000 bond on the remaining counts as well.
All right, and I will do that. And did you understand that, sir?
Ma'am, I just want to say this. My parents is coming from New York. They're here. I'm getting bailed out. We just, the thing was just to go get my stuff. They didn't know where I lived at.
Okay,
that-
I really don't, I'm really cautioning you, really cautioning you, please. Don't comment. If, I would just simply say, if you could bond out,
that's
bond
what I'm
out,
saying.
honor
We
the
got 100.
honor the terms of the, protection order, and you'll be seeing your division judge.
So it's
Thank
$200
you.
right now, right?
It's,
Bond.
I think
we
your
don't-
total bonds, if I'm not mistaken, are at $5,000. Is that accurate?
That's accurate, Your Honor.
That's it.
Wait a minute. Just said you added another 1,000. My bond was $1,000 on the
Yes.
first one. It's $100. You just put another 1,000 on me, so that's another $100, right?
There's 4 new ad charges, 4 new counts. I found probable cause, and there's $1,000 on each count. So now there's a total. Yeah, I know.
But I'm
I
saying
know.
I'm in jail. I'm locked up. I can't call nobody. How?
All right, thank you so much. I've got to move on. I've got such a big docket. Thank you.
All right, so my total bond is what?
5,000. Thank you. Next, I have John Pearson. John Pearson.
He's coming, Judge.
Thanks. Thank you so much.
Good morning, Your Honor.
Good morning. Are you here for Mr. Pearson? Are you with this case? What's your name? Thank you.
I'm John Pearson.
Hey, hold on.
Don't comment, please. And just, I'm going to ask at this time, no comments, don't talk about any facts, okay? Understood? Thank you. And just for the record, this is for 1 count of battery, touch or strike battery, a dating violation, and I did find probable cause on this particular count. And I would just simply ask, is this going into the domestic violence division as a result of the classification of a dating violation? State, do you know?
It, Judge, based on the probable cause, I'm not entirely sure.
I'm not entirely sure either. And the recommended, the suggested bond on this?
Judge, given that the victim is here, she has expressed that she's in fear, I would be asking at this time for at least a $2,500 bond. I don't have any Broward priors that I was able to find.
Understood. And just for the record, sir, do you have a place to live?
Yes.
Thank you. And I would, yes.
I'm so sorry. I just wanted to make the court aware that he's not going to be able to meet the $2,500 bond. I think that he can post around either $100 or $200, so that would be the equivalent of like $1,000 bond. If the victim is in fear for her life, we can certainly, if he has a place to live, we can put him on pretrial release on whatever supervision level that Your Honor feels comfortable with, so that he can actually bond out.
I'm going to set bond at $1,500. I'm also going to place him on pretrial release, level 2, absolutely no contact, direct, indirect, that there is to be no victim contact, not at her place of residence, not through any other means, no firearms, no ammo, no weapons of any kind, no alcohol, no intoxicants, random screenings. Yes, ma'am.
Judge, he took my vehicle. I have no vehicle to take my kids, and he
I
has.
can't comment on that. You have to really take that up with the state attorney's office. They also have a victims advocate unit.
Your Honor, you said random testing also was a
Yes.
violation. Thank you.
To the state attorney's office. Can you, do you happen to have any information to provide her?
Judge, I have a victim advocate with me right now.
Oh,
She's
then
gonna
you
speak
could
with her.
consult. Okay, fantastic. Somebody will be talking to you in just a few moments, okay? Thank you very much. Thank you. And next I have Azim Akim Chowdhury. Anybody? Mr. Chowdhury? Oh, thank you. Good morning. And sir, this is you have been arrested on 1 count of violation of an injunction protective order. I have reviewed the probable cause affidavit, and I did find probable cause. I was going to be setting bond at $500 and ordering no return to that location. This is intra-family, just for the record, and no return to that residence. Do you understand?
Yes.
That's a condition of your bond. So, and I'm not, and I know you understand, and I heard you, and I appreciate that very much. I just wanted to advise you that the protective order is still in place, and if there is a violation of this condition of release, that in of itself could lead you to a bond revocation dynamic, and I just wanted you to understand that fully. Understood?
Yeah, understood.
Thank you very much. There you go. Thank you. Next, I have Lavone Isiha Williams. Oh, thank you. Thank you. Good morning. And, sir, you have been arrested on one count of touch or strike, battery, domestic violence. I did review the probable cause affidavit, and the only question I kind of had state was it looked like the potential of a strangulation, and I didn't understand by my reading why it wasn't, because that is a considerably different classification of an arrest.
I completely understand, Judge. I'm not sure why the officer in this case didn't present it to us
Okay,
as
I
a
just
strangulation charge.
making a notation with regards to the court's reading of the fact pattern, and I guess you'll look at that, but just for the record, I am gonna set bond at $7,500. I'm ordering no contact, direct or indirect, with the, alleged victim. I'm asking, if somebody can please review priors with me.
Yes, Your Honor. He does have a prior carrying a concealed firearm from 2012, so I was just going to additionally be asking that he have no weapons.
And no weapons of any kind, no firearms, no weapons of any kind, no contact, direct or indirect, with the alleged victim. Bond is set at $7,500, understanding that the state is going to be looking into this as well.
Judge, I don't believe that Mr. Williams can make the $7,000 bond. I
Thank
believe
you.
that he can make a $2,000
So noted.
bond.
Then he can see his circuit judge. Thank you, and apply for reduction.
Judge.
Thank you. And Nathaniel Corey Wilson. Good morning. And sir, you have also been arrested on thank you. Thank you. One count of touch or strike, battery, also domestic violence. Give me 1 second, please. And just for the record, I did find probable cause. And I'm just asking indication of bond and any
Yes, Your Honor.
priors, please.
Given the allegations in this case, and he has one prior felony for grand theft from 2015, although it's a first-degree misdemeanor, I would still be asking for a $3,000 bond, given the allegations in the case.
Um, at this juncture, I'm going to set bond at $750. I'm ordering absolutely no contact. No contact, direct or indirect. Do you understand that, sir? No return to that location. I've reviewed the arrest affidavit. I understand the, the complexities of, what's happening and, just no contact, correct? And let the family court do what family courts do, correct? Make decisions, right? Right.
Thank you, Judge.
All right. Thank you. And then Jonathan Martinez. Jonathan Martinez.
He's coming up, Judge.
Thank you. Good morning. And sir, this is an outstanding I'm not sure exactly, State, is this a violation of probation or a straight out capias or?
Your Honor, he failed to appear and the judge issued a no bond capias.
Okay, so you're gonna have to see Judge McHugh, and you will be seeing Judge McHugh on the 9th at 9 a.m.
Judge, I just wanted to make the court aware that Mr. Martinez did turn himself in as soon as he heard that he had missed court and there was
I'm sure that Judge McHugh would be very interested in knowing that and would appreciate
Your
that.
Honor,
Thank you. I don't have any jurisdiction, any discretion rather on this. Thank you. And I think it's Christian Ramos. Good morning. Sir, you have been arrested on one count of domestic battery by strangulation, one count of felony battery. I have reviewed the arrest affidavit. I am setting bonds at $15,000 as to count one, $15,000 as to count two. In the event, State, that he is able to bond out, I am ordering on him under pretrial release, level 2, with electronic monitoring, absolutely no weapons, no firearms, no ammo of any kind, no contact, direct or indirect, no return to that location. Very serious allegations, very aggravating probable cause affidavit for the record.
Judge, may I ask for a photo order to be signed by Your Honor?
Absolutely.
So that Mr. Ramos Rojas' injuries can be documented?
Yes, I understand.
And
Thank you.
I would like to make the argument that he got to $2,500 bond, $15,000 is out of his reach. Unfortunately, I was wondering if Your Honor would reconsider the bond amount.
No, thank you very much. He could apply to a circuit judge. Thank you.
Thank you, Judge.
Byron Ortega. Good morning.
Good morning, Your Honor.
Thank you. And sir, this is one count of touch or strike battery with domestic violence, one count of false imprisonment of an adult. I did find probable cause on both counts. I was asking, first of all, State, can you review priors, please?
I apologize, Judge. Review.
Any prior criminal history?
Yes, Your Honor. He has a 2006 possession of cannabis felony and a 2010 possession of cannabis felony. He was charged with attempting to tamper with physical evidence, but he was found not guilty of that.
Thank you. Recommendation on bond?
Your Honor, I would be recommending a $1,000 bond on count 1 and a $3,000 bond on count 2.
Judge, in lieu of such a high bond amount, I would request to see if you can put Mr. Ortega in some kind of pretrial supervision with a high level of supervision. If there are any concerns about the victim's safety, I would just like to let Your Honor know that the only thing that he can afford is a $1,000 bond at this point in time. So in lieu of the second count being $3,000, maybe some type of pretrial release with a GPS monitor and no
Again,
contact.
just for the record, very aggravating arrest affidavit. I'll set bond at $3,000 as to count one, $1,000 as to count two. I'm going to order him on pretrial release, level 2, absolutely no contact, direct or indirect, with the victim. I'm also going to be requesting a guardian ad litem be appointed. I can't tell directly whether or not, but I know there's minor children in that home. Whether or not they witnessed, I can't, the probable cause affidavit does not indicate such. Any allegations, and any other applications he can certainly make to his circuit court judge. Again, I find probable cause on both counts.
Thank you, Judge. Go ahead.
Abuda Simeon Logan.
He's walking right up, Judge.
Thank you. And just for the record, good morning, first of all, sir. And I did have the opportunity to review the arrest affidavit. I did find probable cause as to, thank you, as to that count. I'm simply asking the state any recommendation on bond.
Your Honor, I would be recommending a $2,000 bond. I was not able to find any priors on Mr. Logan.
Did not, did you say?
Did not.
I can't hear you, I'm sorry. There's a lot of background noise. It's very difficult to hear in the courtroom. I'll go ahead and set bond at $1,000. I'm ordering at this time no contact, direct or indirect, with the alleged victim. Were you on this case, madam? I can't hear you.
That's my brother,
What is your name?
Tanisha Logan.
Tanisha Logan?
Yes, ma'am.
Sorry, there's a lot of background noise, as you could hear. It's so loud. I just said bond at $1,000, or is your family able to postpone?
Yes, I am.
All right, thank you very much, and I am ordering no contact at this time, direct or indirect. Thank you. Thank you, sir. Your family's going to be posting bond. Anthony, I don't.
He's a medical loan, Judge.
Thank you very much. Give me 1 second. And Joseph Gramanzini?
Yes.
Did
Yes, Your Honor.
Thank you. I'm getting there. Good morning. I think I said that sort of close.
You said it correct.
Oh, okay, thank you. And this, maybe somebody can just verify what I'm saying is accurate, but it looks like this is a change of charge. And it's a change of charge as to count number 3, having to do with a change of charge from a battery strike touch to a felony battery as a result of priors. Is that accurate, State?
That is correct, Your Honor.
Okay, and in that regard, is there some kind of a modification
Well,
of
so
the amount?
It's actually not a change of charge as far as I can see. I believe the state filed, and for whatever reason, it never came through magistrate, so it's not
Because
so
it's
much.
saying COC on my
No,
sheet.
that's what see on my docket also, but I don't see that there was ever a different charge. And I don't see that it was ever magistrated, because I'm looking at the, on
So,
Odyssey.
so you're saying you don't see anything related
Right, I don't see any
to
prior
account
bonds.
3?
Correct. On this case number, because it's 19-4216, I see that the state filed an information on April 1st, so it was a not-in-custody information.
And what,
there was
how
nothing
many,
prior.
and how many counts on that information?
Just one. He has other cases because this is count 3.
That's what it's
But on
indicating
this
on-
case number, this is the only charge there's ever been.
Okay, so state, your view, $1,000
Yes, Your Honor, that's what I would be recommending.
on that? If, and I just want to say for the record, if anything needs to be clarified, modified, you are actually going to be seeing your judge, your division judge. It looks, actually, I'm seeing 2 court dates. One for 4/8 at 8:30, one for 4/11 at 9:15. Alrighty? Thank you.
So is that bond out or? Is that with the $500 bond?
And that's the problem, I don't have a full picture. It's a little fragmented, right, right, it's, yeah. Oh, total bond 6,000, but I think he left that space.
He knew it, I heard him talking.
Oh, he knew it, okay, good. 1,000. And Terrence Hill. Thank you. Terrence Hill at Maine, Terrence Hill.
He's walking up, Judge.
Thank you. We're doing so well this morning, I have to say. It's going very well. And first of all,
I got it.
sir, it's a violation of a community control warrant, and you will be seeing your division judge. It looks like on April 9th at 9:45. The other is a capias out of a misdemeanor court on a battery charge with a $5,000 capias. So you'll be seeing that division judge on the 10th.
Judge, Mr. Hill wants you to know that he didn't receive notice of his court date, so he didn't miss court voluntarily. He was wondering if you would be amenable to setting a bond for him.
You know something, I really am not comfortable doing that. There is a bond, but I'm not comfortable in modifying it. This is a battery charge on the misdemeanor.
He has a bond on the KPS. The
Right,
issue is the
and,
violation.
there is a due process, constitutional rights of victims, and that would be substantial. So thank you very much. Thank you.
Thank you.
Of course. And Rudlin, is it Ema? Eyma?
And it's North Broward.
Oh, thanks. Thank you. Hi, good morning.
Good morning.
Give me 1 second. I'm just gonna sign a couple of orders here, not for you, but for somebody else.
All right.
Thanks. There we go. Thanks so much. All righty. And sir, this looks like account 4, and it relates to the, I guess, arrest or for basically what would be a in-jail allegation of a new law violation of criminal mischief, and that relates to, and I'm not looking for comment, but some damage regarding a sprinkler head. So I did find probable cause on that, and I would just do an ROR on that. Thank you.
All right.
All right, good luck. And then Dwayne Michael Rich, and this is traffic, so I should have something. Anybody know where Mr. Rich might be?
He's here, Judge.
Fantastic. And good morning, sir.
Good morning, Judge.
Give me 1 second. What I see, first of all, this is a traffic. It's an operating without. If he wanted to resolve his case today, he certainly can. The license, is under suspension. It has been under suspension. It looks like since sometime in 2016, if he wants to resolve his case, I'd offer him a withholding of adjudication, just no driving without a valid license, obviously. And I can give him as much time as he may need to manage the payment of his court costs of $293, if whatever he needs.
Judge, he would require 12 months, and he would like to upset the judge's offer.
Of course. You're all set. Thank you then. And I'll go ahead then and find a factual basis, no involuntary intelligent waiver. Thank you. And I'm going to
Thank you,
dismiss the accompanying civil traffic infraction. And Clifford Andre Knudsen with a K.
Yes, ma'am.
Judge is here.
Thank you. And all this, sir, good morning, first of all. And if you could just give me 1
Stand
second.
back over here. Okay, sorry.
Thank you. Appreciate that, Deputy. I'm just gonna, I don't see a driving record. Let me just. And these are two outstanding traffic capiases, but I have to say I just don't have a driving record.
Your Honor, it appears that these are both for crossing the street, not in a crosswalk.
Oh, it's like a solicitation, more like a panhandling type of dynamic?
Just not using a crosswalk.
Yes, Judge.
Understood. Got it. Thank you so much for clarifying. And if he wants to resolve his case, of course he can. Yes, I see you do. And it would be a withholding of adjudication, both counts, I'll give him credit, of course, for time served. Are you currently homeless? Is that the dynamic?
Yes, ma'am.
All right.
Yes, ma'am.
And if you don't mind, if anybody doesn't mind, I'll convert any costs for him. I think it's fair to say, and I think it's fair to say that, these
Thank you.
these panhandling laws have gotten, kind of strict. So try to, access the homeless outreach teams, try to use your resources as best you can, correct?
Yes, ma'am.
All right, good luck. Thank you.
Thank you, ma'am. Thank you, ma'am.
Thank you.
And Keith Alexander Trinan.
North Broward.
North Broward, Your Honor.
I see that. Hello. How are you? Okay, so I've got a trespass case, trespass and older, I guess, also trespass. Did you want to resolve those cases?
Yes, ma'am. Yes,
I could hear you.
Okay.
I could hear you. And if you wanted to do that, it would be a withholding of adjudication, same offer. Are you currently homeless? Is that the dynamic?
Yes, Your Honor.
Okay. So, and do you need help with those services?
Yes, I want to get in the Salvation Army for men.
Okay.
Yeah.
Understood.
If I can.
Right.
I haven't tried yet to get in there, but
The way
it's been a while.
Understood. The way the system operates now, you have to go through a basically like a computerized process. But if you if you come to my courtroom, I'm in 6155 Monday morning. I'm happy to assist you.
Okay.
Because I don't have any of the documentation here with me today.
Okay.
But I'm happy to assist. 6155, I'm Judge Ginger Lorna Wren, correct?
Ginger Lord, Your Honor, Ginger Lord.
Yes, the only Judge Ginger, I think, in the circuit. Yeah, 6155. They'll write it down for you. All right?
Your Honor.
All right, thank you.
Thank
You're all
you.
set. Robert Stack.
He's walking up, Judge.
Yes, withhold, yes, on both. Withhold both, convert, yes. Due to indigency, due to homelessness. Good morning.
Good morning.
Thank you. And sir, what I'm seeing is two outstanding pretrial release violation of pretrial release warrants. and they have bonds of $500 each before Judge Poll. And then there's two other outstanding capiases, and I'm not sure if this is also out of Judge Poll's division, but it looks like it's the same case number.
It is, Your Honor. He failed to appear for a status on February 25th.
And Judge, I would like to enlighten the court a little bit.
Sure.
I have some information. Mr. Stack was actually being held in Florida State Prison while he was supposed to have the status. His failure to appear was not willful or substantial. Obviously, he was in custody. So I would like to ask Your Honor if you could ROR him on the capiases and have him bond out for the warrant for pretrial.
I can't hear you. He's being sentenced. His sentence ends tomorrow. So I'm just curious, so how did that happen? How does someone get here? Where were you serving your sentence?
I was at Lake Butler, ma'am.
At Lake Butler. And so what happened? They brought you here? They just brought you here?
Yes, they status checked me for 9 months, and then because I was on the docket for so long, they switched the PD and they forgot I was incarcerated, which I can understand. The case has been going on almost a year.
Interesting. So, could I make a suggestion? First of all, he has a court date in front of Judge Paul on the 9th. So, what, is that Tuesday? That's Tuesday. So, under the set of circumstances, I was just wondering, could he be reinstated under pretrial release and a ROR? I'm asking. Is there any reason he can't? Given the set of circumstances. No, I mean, but understood. It's up to me, of course. But anything. Right, but still, these cases are pending. I don't know the status of these cases. I don't know, where these cases are in the trajectory, of the case. So I don't have access to that information. And I was just saying that I would go ahead, given the dynamic that you just mentioned, and ROR him, correct, and let him reinstate under pretrial release.
As far as that, are you gonna ROR him on the pretrial warrant? Also, he has a $500 bond on the pretrial warrants and a no bond.
What was he going to do? Post bond? I'm not following this.
Well, he has two bonds,
Right? Is he able to post the bond? Any bond?
He's not able to post the bond. He hasn't been working, obviously. So I would request for Your Honor to follow your own suggestion and try to see if he can reinstate it to the pretrial level.
I can't hear you. I'm sorry. I'm just getting information, counsel. It's really difficult to hear, so I apologize. Right. And what was the date of that? I will repeat. Give me 1 second. What year?
Last year.
When were you incarcerated in state prison? Do you know the dates of incarceration?
I left. They sentenced me to 4 years. They reopened my case and sentenced me to 4 years because I had a BOP because of this charge. So I just finished the 4 years. Or it'll be finished tomorrow.
Got it. Got it. I understand now. That makes good sense. Okay, my view then is, why don't you just hang on and see Judge Paul and let Judge Paul make that determination as to whether reinstatement, explain it to Judge Paul. He'll review everything, all right? Thank you. And that's on the 9th. Good luck.
Thank you,
I
Judge.
understand. Got it. And Chandler Thomas Pomaski.
He's walking up, Judge.
Thanks. Okay, I've got a lot of stuff. Hello.
Good morning, Your Honor.
Good morning. Give me 1 second. I'll be right with you. 1 second. Thank you. So let's see what this is, if I can. It looks like a trespass. I'm happy to resolve your case for you if you would like, with a withholding of adjudication. And are you currently homeless?
As of yesterday, I was evicted yesterday, and then they went to the store and they arrested me for trespassing.
Oh, yesterday was a bad day.
A bad day.
That's a bad day.
Yes,
So,
bad day.
okay, so I would go ahead then, counsel, if he wants, if that's up to him, I would offer to withhold, and give him 12 months to pay.
Yes, he would like to accept the court offer.
Done. All right, thank you very much. Then I'll find a factual basis on voluntary intelligent waiver.
Thank
You're
you,
all set.
Judge.
Thank you. Good luck. Jeremy Watts. Also, just for the record, a trespass. Hello.
How you doing?
Good. How you doing?
I'm all right.
Good. Listen, this is a trespass charge, and I did find probable cause. And according to the arrest affidavit, there's been some. I'm just repeating this. I'm not saying it's true or not true. That there has been prior warnings, and if you wanted to resolve your case today, you can, but you cannot go back to that location.
Okay.
Is there anything about that you don't appreciate or understand?
I understand.
Okay, great.
I'll go back.
Thank you. And
All right.
that'll be the withholding of adjudication, then no return. And are you on disability? Do you receive any fixed income or anything like that?
No, ma'am.
Okay, so I would just give him extended time to pay. How much time would you like to pay your court costs? I'll give you whatever you need.
12 months, Judge.
Sure, you're all set, thank you.
All right.
And I'll find a factual basis, no bond, intelligent waiver. And James Fonseca.
He's coming right up, Judge.
Thank you. Hello.
Hey, Your Honor.
Good morning. And this has to do also with a trespass charge, arrest, excuse me. It's actually an outstanding capias. I'm happy to also resolve it for him, if you wanted to, with a withholding. And are you currently homeless, sir?
Yes, ma'am.
Okay, and I'll certainly be willing to convert any costs for him to a lien based on his indigency and his homelessness status, correct?
Yes.
All right, thank you very much and good luck.
Thank you.
And Lawrence Chapman. We're starting to, do you need a tissue? You need tissue? I have tissues. Can you, madam? Well, Susan will get it for you. Sure, of course. Thanks, Susan. Thank you. Oh, all right. Just hang in there. Mr. Chapman, sir, your bond has been posted. I've just gotten informed. I am ordering no contact, direct or indirect, with the alleged victim. No return to that location. Do you understand?
Yes, Your Honor.
Thank you.
That's it.
I have Raymond George Shackner.
I am being told that he bonded out, Judge.
Thank you.
So much.
And Travis Hannah. Good morning. And sir, good morning. And you have a violation of probation matter, and you will be seeing your division judge on the 9th at 9 a.m. Thank you.
Thank you, Judge.
And James Nigel Woods. Good morning, sir. And you will
morning, Your Honor. How are you?
thank you. And you also have a violation of probation hearing, and you will be seeing your division judge at 9 a.m. On the 9th.
Judge, if I may, Mr. Woods would like to see if Your Honor would be willing to have him post a bond or offer him a bond. He's a Florida native. He's self-employed as a mariner, but he has a 13-year-old at home. He's a single father, and he's very concerned about his child. He doesn't want his child to be alone at home. This is a violation of probation for a misdemeanor. It's a disorderly conduct. I don't think that he can feasibly wait until Tuesday. I was wondering if Your Honor could either offer him something or, I'm not sure, Judge.
1 second. You know, I can't, and I'll tell you why. The reason being that I can't is, or I don't feel comfortable doing that is because it's a technical violation that relates to a domestic incident, and I don't know anything else other than that, and I apologize if I felt comfortable, believe me, I would, but there's victims' rights potentially at stake, and I just can't do it.
Judge, is there any services that we can provide him? He's asking how he can try to take care of his child.
Okay, that's a different. So are you saying he doesn't have any relatives?
No, he's a single father.
I heard he's a single father. I'm just asking.
He doesn't have anybody to take care of his child between now and Tuesday if he were to get released on Tuesday. I mean, his child would be alone for the rest of the weekend and for.
You don't
like
have any
approximately 3
parents?
days.
They're not in this county, Your Honor.
Then
Please,
call
Your Honor.
them and get them here.
It's long distance, and
I'm sure your public defender's office will be, I will give you a court order to get your phone. You can make any calls you need to.
Or another option would be, if anything, is have law enforcement go to the house to do a wellness check on the child.
That's a good suggestion.
See if it's involved, and they can place the child in shelter.
Okay, I'm happy to give him a court order for his phone, and I thought that the probation office gave a very positive recommendation that law enforcement will do a wellness check, and if that's the case. But really, where do your parents live?
Martin County, Your Honor.
Okay, well, I'm going to give you a court order to call them.
Can I get a court order to please take care of my daughter? She has to go to St. Anthony Catholic School tomorrow,
Sir,
and then Monday
your
morning.
you're going to call your family. I'm going to give you a court order right now.
I'm in family court, and my son. I'm in Marchman court. Yes, the disorderly conduct from November 2nd, 2017, was a disorderly conduct involving my 17-year-old white male son.
Please don't give. I'm really asking you, counsel.
I'm in Marchman court.
I heard you.
Yes, ma'am.
Heard you. I
Yes, Your
got
Honor.
it. I'm thinking that maybe there was a violation of a court order. I don't know if that's what he's saying, meaning he was placed. I can't hear you. No, I understand that, but what I'm saying is that this has to go before a circuit judge, that it seemed that there might be either a failure to admit or an unlawful leaving after being essentially committed. pursuant to 383. So I think that the point that I'm trying to make is I am very, very happy to, again, issue a court order. And if he was in Marchmont, and if he was in a treatment facility, and he was known to be in a treatment facility, then I'm sure that plans have been made and plans were going to be made. So if you could just, let me do the court order right now, and and I'm sure the jail will assist with that. And the public defender's office could assist with that as well. And just for the record, probation, that warrant is not very detailed. So you look at the warrant and it doesn't say where, exactly where he was committed, that he's under the Marchman order, where was he supposed to be, et cetera, et cetera. There's just no detail.
Judge, I think we're gonna need the Spanish interpreter for the next one.
Thank you. She's in the courtroom.
Okay.
She's here. Thank you. And Madam Interpreter, whenever you're ready. That's going to be for Eric Gonzalez Hernandez.
Venga, señor Hernández.
Thank you. And Madam, if you would raise your right hand, I'll put you under oath. Thank you. And do you solemnly swear or affirm they'll interpret from English to Spanish, Spanish to English, pursuant to a proper, correct rendering from this court to the best of your ability?
I do. Maria Salazar, certified court interpreter.
Thank you very much. And good morning, Mr. Hernandez.
Buenos días, señor Hernández.
And Mr. Hernandez, this is a first appearance hearing. It's very limited.
Señor
I am not.
Hernández, esta es una primera comparecencia y es bien limitada.
And just for the record, you have been arrested on 2 counts of driving under the influence.
Se le acusa de 2 cargos de manejar bajo la
One with an
influencia.
enhanced breath.
I'm sorry, Your Honor.
An enhanced breath.
Y con el aliento alcohólico incrementado, el nivel de alcohol incrementado.
1 count of driving while license suspended or revoked.
Un cargo de manejar con la licencia suspendida, primera ofensa.
And 1 count of providing false information about, looks like a commercial driver's license state. I'm not really.
Y un cargo de proporcionar una declaración falsa sobre la licencia de conducir. Encuentro causa probable.
You do have bonds, and they total right now $1,500. Are you able to bond out?
Usted se le está dando una fianza de $1,500. Usted tiene posibilidades de salir con fianza.
He told me that he could only afford a $1,000 bond, Judge.
That's fine. I will go ahead then and ROR him as to count 1.
Le van a dar la libertad bajo palabra en el primer
And that
cargo.
leaves the bond at $1,000.
Y eso va a reducir la fianza a $1,000.
Thank you.
Gracias.
Is Del home next? Yes. Thank you. I've got different piles emerging. Marquise de Caroian Del Home. Thank you. Good morning. I don't know if the sound is on. Thank you.
Judge, okay, I have Mr. Del Home next to me, Judge.
Yes, I see. Thank you. And essentially, this is an ad charge, aggravated battery, and it occurred allegedly in the detention facility. And I did find probable cause. And just for the record, state, since he's already in detention, 1,000 more. I don't know how you grade that on an in custody?
Judge, because he's serving a sentence and he's not in on current charges, I would be asking for a higher
I
bond.
see.
Because his county sentence time will be over eventually. So I would be asking for, given the allegations in this case, as well as his very extensive criminal history with felonies,
Do
several
you wanna,
felonies.
do you wanna just review some of that, for me, for the
Of course,
court?
Judge.
Give me 1 second, please.
Whenever you're ready. Your Honor.
Oh, I'm waiting.
I'm going to start with the most recent.
Thank you.
2017 burglary of a structure unoccupied. Another 2017 burglary of a structure unoccupied. 2015 providing a false name and trespass. 2013 delivery of methadone. 2013 possession of cocaine. 2013 possession of cocaine. Possession of methadone. Possession of cannabis. 2013 possession of cannabis. 2012 battery. 2011 petty theft, and in 2011 resisting without violence.
Thank you. I would go ahead, just for the record, I'll go ahead and set bond. What are you recommending, 2,500, 3,000? I don't know what you're recommending.
Judge, I would be recommending $5,000 bond, given his priors and the allegations in this case.
Judge, he has somewhere to live if he were to get released. So in lieu of a $5,000 bond that he cannot afford because he hasn't been working, he has a family home that he can go to. Perhaps a pretrial release with a very high supervision if Your Honor feels that he's a danger or something along those lines. He could get level 2, level 1, GPS monitor, whatever Your Honor feels comfortable with. But a $5,000 bond he will never be able to make.
I'll set bond at $2,000, and upon release, he would be supervised by the Office of Pretrial Release under Level 2 Monitoring, EMO. Thank you.
Okay, thank you.
And no contact, direct, indirect, with the alleged victim in this particular case. No contact. Kamar, Sherrard, roll.
Thank you. Can I see your face? Can I see your face? Like your lips? Do you have any cuts or anything? No.
Bless you, give me 1 second.
Thank you, Judge.
You're welcome. Alrighty, and Mr. Roll, this is also allegations of battery on a detained person. And I did find probable cause, and I would set bond at $1,000 and no contact with this individual. Understood, you're in a confined space. Understood?
Yes, ma'am.
Thank you.
Thank you.
And Brandon Woolery, excuse me, Woolery. Good morning.
Good morning.
And sir, you have been, this is a this is an ad charge, number 2. It is for 1 count of robbery with a weapon. Very serious allegations, just for the record. I did review the probable cause affidavit, and I did find probable cause. And I don't know what count 1 is, if somebody could inform me.
Your Honor, count 1 is a first-degree murder.
So noted.
And due to the nature of this offense and that it is a punishable by life offense, at this time I would be asking that you find proof evident presumption great and hold him no bond in this case.
Your Honor, this is not a PBL, this is a robbery with a weapon. It's a first degree, I agree it's a first degree, but it's not a PBL, because it's robbery with a weapon, that's what's before us today.
Understood. Give me 1 second. And as to count 2, I would set bond at $25,000. $25,000. And in the event of release, he would be under pretrial release, level 2, no contact, direct or indirect, of course, no weapons of any kind, no firearms, and that would be that's in the event of release under level 2 electronic monitoring. Understood? Thank you. Jonathan Kyle Lewis. Good morning.
Good morning, Judge.
Good morning, sir. This is, I guess, count 5. It is a possession of cocaine. I did find probable cause. You do have a bond of $1,000. Is that, or is this something different? I'm sorry. I apologize. This actually is a, I don't know if this is a change of charge. I apologize. There's paperwork attached. Out of Judge McCarthy, could somebody help me with that?
I don't see that it's
Because I don't have a narrative on this.
Judge, is a failure to appear on a possession of cocaine.
Oh, thank you. Thank you very much. I don't know when he's due to see Judge McCarthy. It's not indicated.
April 26th.
On April 26th, you're scheduled to see Judge McCarthy.
Yes, ma'am.
Thank you. That's it.
Thank you, Judge.
And Sean Samuel Charles. Good morning. And sir, this represents counts 2 and 3. For 2 is the allegations for larceny, $300 or less from an individual 65 years or older. 1 count of fraudulent use of an ID without the consent of another. This is and just for the record, a very serious allegations in this arrest affidavit. Bond is noted on the face sheet of $1,000 as to count 2, $3,500 as to count 3. I don't know what count 1 is for the record.
I'm pulling up count 1 for you now, Judge.
Oh, thanks. Just so I can get some clarification.
Count 1 is a grand theft auto. These look like they're ad charges. He's being held no bond on count 1.
Okay, thank you for sharing. That's what I'm trying to fill in some of the blanks. All right, thank you very much, and you're all set, sir. I did find probable cause. Thank you. And no contact,
Thank you, Judge.
direct or indirect, with the alleged victim. No contact. Christopher Fernandez. Good morning.
Good morning, Your Honor. How are you?
I'm good, thank you. It looks like, sir, you have an out-of-county hold out of Monroe on a probation matter, so they'll be coming.
Is there any way to expedite that?
Oh, they'll be expediting it, yeah. Definitely.
Thank you very much.
Sure. And Jordan Zachary Wolf.
Medical research.
Medical reset, thank you, just for the record. We're almost there. We're getting toward the bottom of the docket. I just want to let you know. And Richie Joseph.
This is a false.
Okay, that one.
Thank you. And trying to do two things at the same time. You know, that doesn't work out. And Mr. Joseph, good morning. And
Good morning, how are you?
I'm good, thank you so much. And sir, again, this is a very limited nature of a hearing, you know that. And it's for one count of robbery, no firearm, no weapon, one count of battery. And just for the record, I did find probable cause. And on both counts, and I'm asking for priors from the state, first of all.
Yes, Your Honor. He has a prior 2018 grand theft auto and a prior 2018 possession of heroin and other juvenile priors that I don't have access to.
Those are already.
Recommended,
I would be recommending a bond in the amount of $3,500.
Judge, Mr. Joseph has conveyed to me that he can only afford a $1,000 bond. Perhaps we can supplement the $1,000 bond with some type of supervision from pretrial release that the court feels comfortable with.
you know, there's significant issues of dangerousness, just for the record, significant concerns about dangerousness based on the review of this probable cause affidavit. I don't want you commenting, I'm just setting the record. And what I would do is I would do the following. I would set bonds which at $3,000 as to count one. I would also, upon ability to bond, I would place the defendant on pretrial release with an electronic monitor, absolutely no new criminal offenses, no contact, direct or indirect, with the alleged victim in this particular case. Thank you. And what I'll do, can I just, and that 3,000 I'll split between the two counts.
Judge, on the second count, I don't think that he was charged. It said no charge.
I say it again, keep it on one? Keep it on one, thank you. Thank you. And I have Berman Jean.
Judge, good morning, Mr. Jean. Speaks Creole. He understands English. If we slow down a little bit for him, he's been in this country for 17 years.
Oh, fantastic. Okay, sure. And sir, good morning.
Good morning, George.
Thank you. And sir, you have been arrested on one count of burglary of an unoccupied structure, unarmed. One count of grand theft. Give me 1 second. Any priors?
I was not able to find any in Florida, Your Honor.
He does have a bond of $1,000. Is he able to make that bond?
Judge, he can make that bond, but it would be difficult for him to have a additional bonds placed. I see that he doesn't have a bond on count 1, the burglary of unoccupied structure. He only has a bond on count 2.
What I'll do is, I will go ahead then, I'm gonna ROR him on 1. I'll leave 1,000 where it is and just put him on standard pretrial. Standard pretrial. Yes.
Thank you, Judge.
Wait 1 second, madam. I'm sorry, I'm getting some information and it's hard to hear.
We're releasing him to pretrial, however, he has a pending immigration case, and if they pick him up, then we have problems with them then when they're caught up in the immigration system, because sometimes they'll go from the immigration custody to another custody, and then we have a hard time tracking them down. to
I
find out where
understand.
they are.
Okay, so we have a complication that is disrupting my thought, quite frankly, in that it's not gonna be able to be effectuated, I think. So rather than that, I think what I'll do then is I would just set the bond as to count 1. I'll just set that at $500, and we'll see what happens from here, because I really don't know. I understand the process, but he might actually have to wait for this case then to be responded to. I don't know how that goes, unfortunately.
Thank you, Judge.
But you'll advise him. Thank you. And Tristan Tash Barrett Brown.
Mr. Brown? Come on. Oh, that's you, Mr. Tristan Brown? Oh, I'm so sorry. I was looking one way, then looking the other. Okay. Judge, I have Mr. Tristan Brown next to me.
Thank you. He's got 3 outstanding capiases on a felony matter, and he will be seeing his division judge on the 9th at 8:30 a.m. He also has been arrested on 1 count of driving while license suspended or revoked as a 3rd offense. And if you can just give me 1 second, I'll see if I have a record to see if I can make a probable cause finding. Or somebody, here we go. Let the record reflect, I do have a driving record, and he has already, for the record, been habitualized in 2009, as well as in 2010, as well as 2017. So he has several series. And I will find probable cause.
Okay.
Thank you. Sure. And then Patrick Ware.
Medical loan judge.
Thank you. Give me 1 second. And then Travis Brown. Yeah, I'm not sure. Yeah, that just plows. Just got a little disrupted. We ready?
Yes, Judge.
Thank you so much. Sir, I gotta keep moving. I've got to keep
Thank you,
going.
Judge.
Thank you so much. Sir, you have been arrested on one count of possession of MDMA ecstasy. I did find probable cause on that count. You have 4 outstanding violations of pretrial warrants. You will have to see Judge Duffy. Thank you so much.
Thank you, Judge.
Sure. And then I have Jermaine Melvin Howard. Good morning. Good morning, sir. And one second. I've got a new arrest for possession with intent to sell, manufacture, deliver cannabis within 1,000 feet of a school, community center park. I did find probable cause on that arrest. He also has a number of outstanding capiases on his felony case. Those 2 are no bonds. And with regards to a burglary, unoccupied structure, unarmed, there's 3 outstanding capiases, and those bonds total $16,500. He will see his division judge on April 9th at 9 a.m.
Thank you.
Thank you. And Robert Allen. Good morning. Mr. Allen, you were arrested on 1 count of driving while license suspended or revoked as a 3rd or subsequent offense. If you can just give me 1 second, please.
I know y'all homeless.
And just for the record, he does have a prior habitualization in 2015. And I do find probable cause. He does have a bond. The bond is currently $750. What bond could he make?
I don't think that he can afford any bond, Judge. Currently, Mr. Allen is homeless, and he is currently looking for a job to be able to support himself.
I actually had a job I was supposed to go through Monday.
He says that he was starting a new job on Monday, Judge.
Prior state.
Yes, Your Honor, he has a 2013 cell, delivered cocaine at a child care center, possession of cannabis within 1,000 feet of a child care center, a 2012 burglary of a dwelling.
All right, thank you very much. The bond stands. Thank you. Bond stands. Thank you. I need to move on. Thank you. And Michael Marlowe Robinson. Good morning. And sir, you have 3 outstanding violations of community control warrants. You will be seeing your division judge on the 9th at 8:30.
Thank you, Judge.
Okay.
Judge Weeks.
Thank you. And Eugene Siren Salsby. Did you have an announcement?
Yeah.
You stood. Good morning. First of all, you have been arrested on 1 count of possession of MDMA, 1 count of resisting or obstructing without violence. Also, a municipal ordinance. I understand that you have been screened and accepted. No, strike that. Wrong.
The other way around.
The other way around, sorry.
Mr. Salisbury is currently on pretrial supervision in case number 18013369, CF10A, possession of substitute cathinones, possession of cannabis 20 grams or less, unlawful use, false name, or identification of another, resisting, obstructing without violence.
Okay.
At this time, we're requesting a revocation of his supervision.
Okay, so I apologize. I thought it was going in a more favorable way, but it's actually going in a revocation dynamic. And I will go ahead and grant that. So those bonds then are going to be revoked based on the new arrest. And again, I did find probable cause on all counts. Give me 1 second and I will set bond. Thank you. Oh, you want me to?
Yes.
Yeah, 1 second. But it's 1, 2.
She has 4 counts.
Got it. All righty, thank you. As to the new law violations, sure, of course, I'll set bond at $1,000 as to count 1. $1,000 as to count 1, $100 as to count 2, and an ROR as to 3. Thank you. Good luck. And Charles Bush. Thank you, sir. Almost done. Sir, good morning. And you have been arrested on 1 count of possession of cocaine, 1 count of possession of drug paraphernalia, possession and or use. I did find probable cause. 1 second. I did find probable cause as to both counts. There is a bond of $1,000. $1,000 as to count 1, and $100 as to count 2. Or is that no charge on 2?
It's no charge on 2, but Judge, he cannot afford bond on the possession of cocaine count 1. Is there any way that the court could consider maybe some type of pretrial supervision?
Could priors, please?
Judge, he has 2 prior arrests, but all the charges were declined.
I can't hear, I'm sorry.
Wait.
Can you stand up, madam? I hate to ask you that, but I'm having a terrible time. It's very loud in the background.
He has 2 failures to appear. Most recent failure to appear was March 5th of this year.
On what case?
It was on a misdemeanor case.
And what happened to that case? Does anybody know? You have a place to live, sir?
No, homeless.
Oh, you're homeless.
I think they.
Well, that would explain the missed court date. All right. Well, the bond will stand. Thank you very much.
Thank you, Judge.
I don't know what else to do. Lucas Gorzalek.
Oh my God.
Good morning.
Good morning, Your Honor.
Sir, you've been arrested on 1 count of felony grand theft, and I did find probable cause. You do have a bond of $1,000.
Okay, so it's possible to...
Judge, he was going to go into treatment to a halfway house for 60 days. Is there any way that
IRT, actually.
he was gonna go to IRT for 60 days on Monday? Is there any way that we can allow him to go on pretrial to IRT?
Yeah. Sure. We can do that. You've
Thank
already
you, Judge.
How did you? Through what means did you get access? Through what means did you get access to BARC IRT? Was that, did you walk in? Did you just walk in voluntarily in the community? And you
I've been there numerous times, and they know me, and they know my situation. So what happened was I relapsed about a month ago, which led to this, and I literally was supposed to have a bed, 2 days ago yesterday, and then I got, obviously what happened. I got arrested on Monday.
It's and have you tried any kind after that? When you step out of that, what are you doing?
I get a sponsor. I mean, usually when I'm on point, I get a sponsor. I live in a halfway house. You know, I got a support group.
All right.
I actually do everything that I have
So
to do.
I would go ahead and ROR him to pretrial with the provision that the court will allow him to be admitted to Bark IRT. I'm not ordering it, meaning I'm accepting his voluntary admission into Bark. The difference is I'm not doing anything to facilitate that. Does that make sense to you, sir?
No.
Okay. Well, what that means is, so you're going to be supervised by pretrial release. That's number one. I'm going to ROR you, right? And
Okay.
right. And, you know, if you don't get into Bark, like you say you're going to get into Bark, right?
Yeah.
That's what you're saying. You're already admitted into Bark.
I will, yeah.
All right, so go
you're saying
ahead.
you
I'll
take
just
my-
go ahead and order him into Bark, first bed available, and successful completion, correct, to IRT. That's what you're saying.
Yeah.
All right. Let's see what happens.
Thank you, Judge.
All right, good.
You can go now.
No.
Bush, Charles Bush?
Yeah. So, no, I have it.
You have it, oh, okay.
I have it. All right, thank you. And Ray Monty Blaylock.
Broward.
Thank you. Mr. Blaylock, good morning.
Good morning, Judge Leonard. How are you, ma'am?
I'm good, thank you. And sir, just for the record, you have been arrested on one count of grand theft. I did find probable cause. You do have a bond. Can you make $1,000 bond?
Well, ma'am, I do work 2 jobs. I lived in the same address for over 20 years. But I am taking care of both of my minor grandchildren right now, and I get paid every 2 weeks. I don't get paid until next week, and I just paid my rent on the 2nd. It would be really hard for me to make that $1,000 bond. I was wondering if
what
you
can
could
you make?
RR.
Can you make anything?
Well, $1,000.
No, I'm asking, could you make any amount?
I mean, I have $100 in my account that I came in with, ma'am. I'd be willing to put that up right now if you let me out.
Any prior?
Yes, Your Honor.
Give me 1 second, sir.
Yes, ma'am. Thank you, ma'am.
2015 felony petty theft, 2013 felony petty theft, 2012 felony petty theft, 2011 felony petty theft, 2010 felony petty theft, 2009 felony petty theft, 2009 petty theft, 2005 possession of cocaine, 2005 possession of cocaine, 2005 dealing in stolen property, 2004 6 counts of dealing in stolen property, and 1999 burglary, and 2000 grand theft auto.
I've completed 2 separate theft kleptomaniac programs and a drug program. I've been doing really good for almost 3 years, and I relapsed this past Thursday, 2 days ago. And I went into a store and took some items. I'm sorry. I didn't mean to talk about that. But ma'am, I do take care of a 6-year-old and a 9-year-old grandchildren. I have 2 minors in my custody. My next door neighbor has them right now, and I've been in the same address for 20 years. And ma'am, even though I have this incredible lengthy record, I've never missed a court date. I come to court. I take my punishment for whatever I've done. I just want to get back into my program and get my things going again, ma'am. I'm sorry for this. Just ask that you please ROR me, and I will make my court appearance. I've never, ever missed a court appearance in all these 25 years here in dealing with Broward County. And I have been in the same address for a little over 21 years, ma'am.
You know, I'll go ahead and set bond at $100, put him on pretrial release. You know, no new criminal offenses, obviously. No new
Yes,
criminal
ma'am.
offenses. I mean, you know, simple strategies, you know, don't go into a retail store alone.
I'm going
We
back
use
into my
that, we
theft
actually
program,
use, you
ma'am.
know, use that strategy in mental health court pretty effectively for people
I'm
with
going
brain
back into my
injuries. So
program.
I'm just commenting. you know,
Okay, but I
this
am
is
gonna go to my program Monday morning, ma'am. I need to get back into this before this.
pretrial release,
snowballs
no new
again.
criminal, okay, you're gonna have to report to pretrial release upon your release, understood?
Okay,
I'm
now I
putting
have
you on
100
pretrial release.
So I'm just released, I don't have
No,
to
you
pay
still
my
have to pay
$100?
$100 bond, I want you to,
Okay, I have that in my account. How do I do that immediately?
they'll help you.
Just what happened?
Ma'am, you have a great day. Thank you for this chance.
Wiley Walton. Almost done.
Walking right up, Judge.
Thank you. And, there's,
Eric Walton.
Judge, I think that there's he was saying that his name is Eric Walton, but
I'm just reading the paperwork that I've got, so if that's the case, can't comment on that. First of all, he has been arrested on 1 count of driving while license suspended, third or subsequent offense. He's got 2 outstanding felony no bond holds. And he will be seeing his division judge on the 9th at 8:45 with regards to the driving while license suspended or revoked. Just give me 1 second, please.
thank you, Judge.
You know, State, I don't have a driving record. I can't find, unless you can look at your record to see if there's 2 priors.
Yes, Your Honor, let me pull that up.
I don't have access to.
Would Your Honor like a copy or just me to read it
Just,
into the record?
just into the record.
Okay.
That'd be great.
He has a 2005 driving while license suspended, a 2006 driving while license suspended, another 2006 driving while license suspended, a 2004 driving while license suspended, and a 2003 driving while license.
All right, thank you. So I will find probable cause as to count 1. Thank you very much. And there is a bond on that of $750. Thank you.
Thank you, Judge.
And Duriel Aiken,
Medical reset.
medical reset, thank you.
Yes, you're welcome.
And Kirby Telsine,
Medical reset.
thank you.
Welcome.
And Ethan Hopkins.
He's walking up, Judge.
Sure.
Good morning, Judge. How you doing?
I'm good. How you doing?
I'm doing all right.
Good. Now, I've got a lot of family here with me in the courtroom, and they've been here all morning long for you. So I was wondering if maybe just one by one, if you don't mind, just introducing yourself for the record.
Okay.
Because I'm going to stand up only because I can't see. Sure.
I'm Kendra Hopkins, the sister.
Sure.
I'm Gwinnett Terrell, his auntie.
Yes.
Troy Patrick, his cousin.
Thank you. And this is just for the record, a burglary with assault or battery, but just give me 1 second, please, because this is a little confusing because my notations on my package indicate that it looks like Judge Lee magistrated this case and made findings back in March 30th.
He's been in a coma in the hospital because he was shot in his face on March 29th.
I could tell you, Honor, I'm here every weekend. I was here with Judge Lee. I think what he does on some of the cases, he makes himself some notes, and then when the cases are reset, he doesn't erase the notes. That would be my guess. But
He made actual findings.
I could tell you, Honor, we never heard it. I was here last week, and I could tell Your Honor he.
Okay, so in other words, you're thinking that this was not heard because he was not here.
Correct. This
He
has
was
been reset
hospitalized.
already.
Is that what you're saying?
Correct.
I see.
Judge, I would like to, first, before I forget, I would like to ask for a photo order. Mr. Hopkins has extensive injuries all over his body, and I would like
That's
for
fine,
those
it's
to be
fine.
documented.
It's fine. All you have to, counsel, all you have to do is ask. All you
Thank you
have
so
to
much,
do is
Judge.
ask. Okay, so just for the record, I think we clarified that issue, that this defendant has never been magistrated before. Okay. And so I'm just curious, so where was he hospitalized, just so I can get some
We
context?
found out yesterday he was at Memorial Hospital.
Okay, so in other words, he was hospitalized.
From the day of the incident on March 29th.
Okay, give me.
He's been missing.
He's been
since
missing.
the 29th.
Understood.
Through Facebook.
Okay.
No one ever contacted the family, let us know where he was. He was shot. We put a Facebook status up that he's been missing since the 29th.
Right.
Someone told us that he was in jail.
All right. So give me 1 second, if you don't mind then, because I have to tell you, I thought that this case might have already been magistrated.
And Judge, I think my office thought that as well, because I don't have his packet here with me, and BSO is reflecting that his bond is no bond, and typically, when they're being held just for magistrates, the status is HG, which means hearing, and in this case, BSO Picks is reflecting his bond is no bond.
First time he showed up to BSO was
So,
yesterday when he was released
I'm not
from the
sure where the
hospital.
disconnect is, but I also.
I don't know, but let me do first things first, and then what we can do is I can give you my packet.
Okay.
If you don't mind.
Of course, Judge.
Sure. Okay, thank you very much. I have reviewed the probable cause affidavit. Sue, can you share this, and I will, and I am going to ask the family, again, no comment. No comment, again. What? And you have a copy?
I have a copy.
You're fine, okay. Because I just want to, again, just acknowledge that this is a really early, limited hearing, just the beginning. I think, you found him, you know where he is, you can see him. That's a positive, correct? Okay. Sure.
A $4,000 bond.
Okay.
I can afford $1,000 bond, ma'am.
All right,
Please,
thank you.
work.
I would not comment right now. Please don't comment right now. State.
Judge, I would be asking in this case that you find proof evident presumption great and hold him no bond given the allegations in this case. It's a punishable by life offense.
Do you know which division this case is going to be heard?
Judge, it'll be in front of Judge Colra.
Judge Colra, thank you. Now, it's a punishable by life offense, you're saying,
Yes, Your Honor.
because, why? Because
Judge,
were there I'm just curious, because because I don't see that he was armed.
No, Judge, it's a burglary with a battery is a punishable by life offense. So the allegation is that he burglarized by entering into the home and then committed a battery on the occupants of the home. And that is a punishable by life offense.
That is a punishable by life offense. It also indicates allegations that there were children in the home.
That's correct, Your Honor, 2 children.
All right. At this time, then, I will go ahead and I will make a finding based upon my review of the probable cause affidavit. The court finds that there is proof evident and presumption great. And I will indicate a no bond hold at this time, understanding the seriousness of the allegations in its totality. And again, this case is going to go before a circuit judge, and it's very early in these proceedings. All right.
Your Honor, I need to object to the finding of proof and presumption grade on this case after reviewing the probable cause affidavit. There are a lot of questions and there's a lot of issues with this probable cause affidavit. The 4th DCA is clear. Proof and presumption grade actually goes beyond the beyond a reasonable doubt standard. Finding proof and presumption grade says the state would win today on, I'm assuming, nothing but this probable cause affidavit, as the state has made no argument. They have proffered no witnesses. They have proffered no additional evidence beyond this probable cause affidavit. This probable cause affidavit starts by saying the officers were called to the scene because of a shooting. It is Mr. Hopkins who was the victim of the shooting. The officers were not called because of any burglary. They show up and they talk to who's allegedly the alleged victim, who says he had to shoot Mr. Hopkins. There's no sworn statements in this probable cause affidavit. There's no sworn statements from any witness in this case. The officers show up and they find Mr. Hopkins in the street, shot in the head. It does not say who they talked to. It does not say why they believe those people. We don't know who called. This is all hearsay. They make mention that the alleged victim says there's a video. The officers don't even bother looking at the video. The video is not here today for us to look at. All we have is an officer saying he shows up, sees Mr. Hopkins dead or shot in the street, in the head, and that he speaks to an alleged victim who said he was scared. That doesn't establish that there was a burglary, let alone a battery.
Thank you. And State.
Your Honor, as the case is now, you can find proof evident presumption great on the basis of the probable cause affidavit. If defense counsel wishes, then once the case is in the division, an Arthur hearing can always be held, where additional information would be given.
I would just say to Your Honor, justice delayed is no justice at all. And if Your Honor does find proof and presumption grade, it is within your discretion to set a monetary bond, and on these facts,
Thank you. I just want to denote that in the interest of completeness, I understand your role, of course, but I just wanted to state in the interest of completeness that according to the sworn arrest affidavit, that the arrestee broke the front window and forced his way into the house through the broken window. The arrestee entered the residence, chased the victim around the residence until he caught the victim and grabbed him. So I will go ahead, I'll stand by my ruling. There will be, I'm sure, a subsequent hearing on this matter. Thank you very much, and I'll note defense's
I would just say to that last point,
objection.
Your Honor, we have no indication of who said that, if that was sworn, or who made that statement.
Well, it is sworn. It's a sworn affidavit.
I could probably guarantee the officer was not there to see it. I do not know who.
No, I'm just simply saying, I'm reading from a sworn affidavit, that's all I'm saying. Understanding and appreciating and noting your objection. All right, so thank you very much, and the case will continue on. Thank you. I really don't know of the next court date. Any information on that? It's not posted as of yet, but I'm sure it will be shortly. All right, thank you. That concludes this morning's docket.
The court order.
Two
Sorry.
more.
I just wanted to, I was trying to remind Mr. Dressler about the court order.
We got it.
Thank you.
Did I miss somebody?
Yes.
Oh, wait, I missed a couple, I apologize. Who was that? Jermaine Walker.
All right, Your Honor.
Thank you. Good morning. And
morning,
sir,
ma'am.
this is an ad charge, count 5 of robbery, no firearm, or a weapon. And,
And one of them was
this
a traffic
is,
charge.
I'm gonna, ask for some clarity on this, because this paperwork I have is not clear to me. It's indicating it looks like there's a no bond on 1 and 2.
No bond hold for magistrate.
And then, as to this particular it looks like a capias.
Do you have the probable cause affidavit
I
for
don't.
the underlying? Okay, I'm gonna print a copy
I
of
don't.
that for you.
And then the last person after I'm done is gonna be, Miss, Evans Balson.
Excuse me, Judge, can I say something, please?
I wouldn't
I want to talk about the facts, sir.
say anything at this moment.
Yes, ma'am.
I do. Yes. So, as to counts 1 through 4, is there anybody that can review that with me?
We're not here on that. The only
No, I
reason
know
here-
we're not here on, but I'm curious as to what they are.
Judge, he was released, pretrial released on grand theft auto and dealing in stolen property.
He's being held no bond on count 4, which is the count 1, if Your Honor's looking at the capias here, the burglary battery. He's being held no bond on that. But he came through on that, and in filing, the state added a robbery charge.
I see, okay, thank you so much, that helped
So we
me,
just need
thank
to
you
set
very
bond on
much.
robbery.
I'll just, 5,000?
No problem, Judge.
Thank you very much, thank you, sir.
Excuse me, ma'am. Can I
Yes.
say something, please?
I really would not comment, so there's nothing that I can do at this particular hearing. I would hold your thoughts.
But dealing with stolen property and grand theft auto, them charges was no info, they were dropped.
Okay,
Cause I was out on a felony bond, that's why they didn't give me no bond when I went to marriage court for the first charge.
all right, thank you. Thank you for sharing that, I appreciate it, thank you.
Just so you understand, Mr. Walker, you're not being held on that. You're being held on the newer charges, just so you know.
And then lastly, Mr. Walker, thank you, sir, thank you. I don't mean to frustrate you, but there's nothing I can do from this level. And Jermaine Walker?
Yes, ma'am.
Oh, I'm sorry, I apologize. Evans Balsine, thank you.
And I could tell Your Honor, this is a change of charge. Originally, when it came through, it was charged as a burglary across county lines.
Yeah, I see that.
At magistrate, I forget who the judge was. The judge just found burglary, and the state has just filed it as burglary. The bond was originally set at $1,000. He has a no bond hold anyway. I would have
Understood,
no
I'll let the
objection.
bond stand, noting that modification. Thank you. Thank you, sir.
His bond was,
Was it not 1,000 on this count? Oh, maybe I misunderstood.
What was it?
bond, correct, consignment status. I had 10,000, he was given a $10,000 bond, pre-trial GPS level 2.
That's what I have as well.
I see,
That's what I have.
I see. 1 second. I don't have a narrative on this.
Was this not the count 37? 'Cause that's what I'm looking at, count 37.
This is showing two.
Count two.
And so the idea, the issue of change of charge from burglary, unoccupied conveyance, unarmed across county lines. Changing it to, is that going to that, from that?
It's going from across county lines to just a straight burglary of an unoccupied conveyance.
Okay.
Because he's being held no
So-
bond on so much stuff, I'm fine with the
That-
$1,000
Let it
you
standing.
wanted to.
Very good, thank you. So essentially, that the bond is the same on that count, sir. All right, thank you very much.
Was pre-trial and GPS? Keeping the same terms and
With GPS.
All other terms remain the same. Thank you, sir, good luck. And that concludes the hearing. Thank you all.